Welcome to your Key Discovery Point. I am Brett Burney from Nextpoint, joined by Doug Austin from eDiscovery today. Another interesting case, as always, Doug. This one having to do with BYOD, bring your own device. And as I was reading through this case, I became really enthralled with how much this touches upon the control question when it comes to, like, especially corporations, right? Organizations over employees' devices. Every employee has some kind of a mobile device, but how much control is required over that mobile device in order for the corporation, the organization, to actually collect information, especially if this is a BYOD. This is typically a personal device that an employee brings into the company. And if the company has to collect information from those devices because they got to produce it, how much control is required? I liked how this case kind of went back and forth, or just kind of explored this interesting question here about the collection. And notably, something else that came into play here was the employee handbook was also one of the important factors here into whether or not that company had control over these devices.
Yeah, and I think this case is interesting from several aspects. First of all, it's a special master ruling here because basically
Right.
the parties had numerous discovery disputes, so the court decided to assign a special master, in Tennessee they assigned a special master Todd Presnell. This was a big issue to be ruling on, and absolutely, the plaintiff Allergan was essentially trying to require Revance to produce, to basically collect from and produce from mobile devices of several of their key employees.
Right.
Ultimately, the part of the determination came down to what was in their employee handbook and
Right.
their, and their BYOD policy. And the handbook search policy, of course, said it only applies to company property, and the definition of computers explicitly includes other company owned items. And then the BYOD policy basically only, while Allergan said it gave Revance control of the devices, allowed Revance to, remotely wipe them if the device was lost and so forth. Revance said the policy isn't as sweeping as Allergan claims, and that permitted business
Right.
activity was limited to email. Obviously, a lot of people, though the policy might say it's limited to email, that doesn't mean, that individual employees might not be texting each other too, but at least in terms of the policy, that's what it stated. One
Right.
of the things that's notable in how Special Master Presnell considered this case is he looked at I'll get to that at the end. I'm going to go back to that. But he considered the
Okay.
case in Ray Pork antitrust litigation,
Antitrust. Right.
which was a real key case from a couple of years ago, where basically it was a similar issue, and the court ruled in that case that the BYOD policy didn't grant the employer control over text messages because it didn't explicitly assert ownership control or the ability to access them, even though they had the ability to remotely wipe the devices and what have you. One thing
Right.
notable about that case is that the plaintiffs were smart enough to also issue Rule 45 subpoenas to the individual employees, and the court granted those subpoenas. They basically are denied the motion to quash those subpoenas. So that was key here. What's key, if you go back up a couple of paragraphs, I think that paragraph right there. In a footnote to the case, Special Master Presnell noted that Allergan chose not to issue Rule 45 subpoenas.
Oh. Okay.
So basically, they rolled the dice with this one. Basically, we're going to get it from the defendant, and ultimately, In both cases regarding the handbook and regarding the BYOD policy, Special Master Presnell agreed with the defendant Revance, basically finding ultimately that not just through via the legal rights standard, but also the practical ability standard, Allergan didn't establish that Revance had control over that data on those devices. So,
Right.
yeah, so ultimately, he ruled they didn't have control and denied their motion to compel searching of the devices. So, I mean, a big lesson here, and I think we've seen it in a couple of cases. We also saw it in the Charles Oakley case against MSG at Madison Square Garden, where he basically requested mobile device data from the defendant, but also did a Rule 45 subpoena to the individual employees. And again, those subpoenas were not quashed. I think that's going to be, that seems to be becoming a standard where the corporation isn't going to necessarily have control over those BYOD devices, which are the predominant devices in most organizations, unless their policy gives them some level of control. And if you are a requesting party, yes, you can try to go after it from the defendant or from the producing party, but you can also, or you should also consider doing Rule 45 subpoenas to the individual employees of those devices, because if the employer doesn't have control, the employees do. And so far, we're seeing that those are routinely granted, and the motions to quash are denied.
This case falls under sort of an umbrella that a lot of people have been talking about in this PCC, possession, custody, and control, right? And you already alluded to the fact that there is a couple of different approaches to this, a legal right standard and a practical ability standard. I know at Sedona Conference, we've talked about this, and Judge Peck has talked about this. He has quite some good insights into, what should we be looking at from possession, custody, control. What I think I found interesting, or at least what I took away from this case here, is that it would be technically possible to do exactly what the plaintiff is asking for here. They could have collected all of this information from these personal devices. In fact, I mean, just purely from a practical standpoint, that is possible, a technical standpoint as well, that would be possible. But what seemed like it protected the defendant here was the fact that they did have an employee handbook in place. And I like that, because a lot of times when I'm consulting with organizations, I do ask them, do you have any kind of an employee policy about, mobile devices and email and how they access it? And, these are things that are not very fun to talk about. Nobody wants to talk about an employee policy or handbook, but they are important. And I like that this case brought up the fact that that's exactly what the special master was looking at. And the fact that they interpreted the employee handbook is that the organization does not have control so much over these personal devices. And that actually protected them from having to go through and collect some of this. Now, I know there's some other nuances that are in here, but I just like the fact that it emphasized this aspect. These are not sexy things to talk about, employee policies and handbooks. But boy, Heidi, it's great that when you have it in place, that you can refer back to it as like, this is our policy and the way that it goes. And I'm just glad that this case highlights that.
Yeah, that's a great point, Brett, because, one of the things you kind of sometimes say, why do we have all these stupid policies and employee handbook and a BYOD policy? This case illustrates that. I mean, we've had other cases. I've covered lots of other cases where parties did have to basically produce data from mobile devices because they didn't establish either the devices were company owned or they didn't have a BYOD policy that clearly set what the policy it is in terms of control of that data. And I think that's one of the things that's a big lesson learned for any company who thinks that at some point their devices might be requested in litigation, is establish a BYOD policy that clearly spells out what level of control you do have.
And I just one other thing, and I didn't read the full opinion here, Doug, but Today, it's not that difficult to do some of this, especially with mobile device management. I don't know if Revance here had a mobile device management system in place, but there are plenty of systems out there that can definitely separate business communications on a device from personal communications, that kind of a thing. And so today, that's even easier, I think, to do. Now, I didn't get a chance to read the entire case opinion, but you link to Minerva 26, formerly eDiscovery Assistant, where you can go and read the entire opinion. And in fact, Kelly Twigger from Minerva 26 also does her own case of the week. I think it's like a video podcast as well, where
Correct.
she went into a whole lot more detail on this as a BYOD policy, the key to determining employer control over employees' personal phones, exactly what we were talking about.
And I'll just say hat tip to Kelly, because I mean, this is, when I saw her discuss this case, and I was like, okay, this is a good case, especially when you compare it to a couple of these others where the requesting party was smart and kind of did the belt and suspenders approach. This one, this is a real lessons learned kind of case.
Good. I'll make sure we have that link in there. And then we've also had a webinar at Nextpoint not too long ago about remote data collection methods. So, in many cases today, there's even tools that we can remotely collect even from mobile devices if you have to. If you don't have a policy in place and you do have to collect from mobile devices, one of the things that we do at Nextpoint and the Nextpoint Law Group is we help consult on those things, and use some of the tools to be able to collect that, because if you do have to collect from that, it can be, people don't like to give up their mobile device. And so it's important to have some of these mobile collection systems. I mean, even like Mode 1, for example, and some of these other tools that we use and put in place. So that's good. So the key discovery point today is, well, frankly, I want to say, if you're a corporation or organization, make sure you have an employee handbook that addresses, bring your own device, because I think that this case certainly makes that pretty important, Doug.
Yeah, and I would add, if you're a requesting party, take the belt and suspenders approach. If you're going to request it from the opposing party, also consider Rule 45 subpoenas to request it directly from the employees, because while one may not be granted, the other may be.
Well said, my friend. Thanks, Doug, as always, for joining us, and we'll talk with you next time.